Hi and welcome to Studio Legal. Today we are going to talk about power of attorney. Why is a power of attorney executed and what is the purpose behind it? Let's find out. It is executed so that your business continues with ease even in your absence. For example, you can sell, purchase, gift, mortgage your property, rent out your property, pay income tax, attend court cases, handle bank accounts, fixed deposits, mutual funds, demat accounts, execute and collect important legal documents in your absence. And how is it possible? Because it is done by someone else. A person you authorize to perform such acts, such business on your behalf. So which are the parties which are formed under a power of attorney? There are two. First one is the executant, that is you. You are the person given power to do such business on your behalf in your absence. So you are the executant. And who is the other person? The other person is the constituted attorney, the person authorized by you to work and act on your behalf in your absence. So first one is the executant and the other one is the constituted attorney. So what kind of powers does a constituted attorney get through this document? Simple. The constituted attorney can sign on all the important documents on your behalf, which includes the sale and purchase agreements. Similarly, this person has the right to appear before the sub-registrar's office on your behalf and register all these important documents and transfer the property in your name or any other person's name. He can also sign on the transfer forms which need to be submitted before the society to transfer a property from one person's name to another person's name. This person also gets the right to handle all your bank accounts. That means this person can sign on your bank checks, bank forms, open a bank account on your name, on your behalf, and also create an FD on your behalf with your money. Also, this person can handle your demat accounts and mutual funds account, is also authorized to buy or sell shares on your behalf. So these are just a few examples of all such activities which the constituted attorney can perform or can do on your behalf if you are not available in person to complete such activities. So if you are executing a special power of attorney or a general power of attorney, you have to be very careful while executing the same. The most important question: to whom can you give such powers? Anyone whom you trust. You can give such powers to your blood relatives, your other relatives or friends. Do all get same kind of powers? Of course not. Only the blood relatives get more powers than any other person to perform all such business on the executant's behalf. Is registration of this power of attorney before the sub-registrar's office compulsory? Well, in some cases, yes. But in some cases, a notarized power of attorney is also very much valid. If you want to create a power of attorney, whether specific or general, you can approach us and visit our website www.thestudiolegal.com. We will help you with the drafting, notarization and registration of power of attorney with ease so that you can perform your business even in your absence. Please like, share and subscribe to our channel Studio Legal if you found it useful. This was it for today. Thank you for watching till the end. We will see you in the next one.